what do they see in a particular application, like whether this is patentable or not patentable?
A lot of patents which are there out there are just copy of some research paper, some here and there, and kind of things. Not really innovative, but it just gives a little bit of count kar diya hai.
This is something which you design in a way that you want to actually hide, at the same time have a patent around it.
If you're not explaining what you're doing, then you are guaranteed to fail.
Like in terms of, can they get a blanket protection for that technology?
If you get a patent office does not care if somebody copies you. It's your responsibility to find who is copying you, take him to the court.
So can you take us through the process of patenting?
If there is a good side of a patent law, there will be a bad side of it.
I mean, it's just a text entry in a database.
But people don't buy patents. People want to buy outcomes.
Patenting has become a capitalistic game in this society rather than what it originally was meant for, like to kind of progress society, advance civilization. Great. So, hi Govind, welcome to the podcast. And let's start with your background and what is Arctic Invent.
Sure. No, thanks, Bandhan, for having me, and it is really a pleasure to have to be on your show. My background is I started my journey from being from a tier 3, tier 4 city of India called Pratapgarh, and then eventually, as it happens that my parents wanted me to get a different, better education from the city where I was. So I kind of did a lot of schooling from different schools, but ended up doing engineering like everybody does. I could not qualify for some of those competitive tests, but ended up being an engineer. And then while doing engineering, it was an era where there was a big bus would come and people will be filled and taken into a factory of softwares, irrespective of whatever you study. And I kind of felt that even though I like technology always, but I felt that maybe software engineering is not something I want to do. And so while third year of the college, I got exposed to intellectual property patents as a concept.
Okay.
Where there was a coursework, and then I got an opportunity to do a summer school. So there I got an opportunity to understand, what is IP. So I realized that maybe, okay, this is something that sounds interesting, a little bit offbeat and something I can do. So then eventually, once I finished my college or almost finishing my college, I got an opportunity to work with a company called CPA Global. Now it's Clarivate. And I started there as analyst there, where my job was to kind of understand patent as a subject, help companies to make sense of that data.
Okay.
And then 5-6 years down the line, I realized that maybe corporate is something I want to look at beyond.
Right.
It was going well. And then with a couple of co-founders which I've known, and we started Arctic Invent. Arctic Invent is essentially a European subsidiary of two IP companies. And we started to serve the startup community in Europe as a start.
Okay.
And my co-founders, seasoned professionals in IP, started to work with startups. And I think what we are seeing in India now, it was 2012, 2015 was like European region where there was a lot of investments coming in. Nokia and kind of companies were shutting, but the talent was actually coming out and creating more businesses and startups.
Okay.
So that's how Arctic has started to serve those startups on IP.
Right.
As we, of course, progressed in our journey, we also took those expertise and started working with India as a market, as an ecosystem. And along the journey, we are serving corporates and startups
Right.
in India and helping them on IP. So that has been the journey. What is Arctic Invent is all about. That has been my journey. It's been almost 20 years. I've been in the IP. So yeah, that's about
Great.
it.
So you started with the European startup ecosystem. But like at that time, because even I feel that even at that time, European market would have been very early in terms of deep tech or startups or IP. So what led you to kind of understand that, okay, startups is a good market, or like, because otherwise back then also corporates would have been a larger market than startups, right? Because they also have the paying capacity, and IP as a whole is very expensive and capital intensive thing.
So I think it's also like doing a startup ourselves, right? Because when we were starting out,
Right.
no corporate will give us the business, right? And in the corporate world, nobody's fired to hire a top company versus a small, new company.
Right.
And I think deep tech back then in Europe was underserved, and same in India right now. I believe
Understood.
like still it's misunderstood. Startup needs a different kind of mindset.
Yeah.
My co-founders were coming from startup background. They have done their own startups in their journeys, so they knew that it is a market where people need a lot of handholding. They don't need a lawyer. Basically, they need somebody who understand business, who understand technology, who understand law, who understand the funding journey and a business building journey. So that was actually the thought, and
Right.
that was something that helped us to grow. It's not that we don't serve corporates, to be fair. We do have corporate clients, but I think our DNA has always been more efficiency on the fixed fees, kind of giving them opinions which is sensible and business wise. So that has been our way of building the business, and that's our DNA. Yes.
Understood. So since you have mentioned this, so what is the requirement of becoming a professional in IP? Because there is someone you can go and do an LLB or and then do a specialization in patent law or similar stuff. But at the same time, there are also people who are IP consultants, patent agents, or similar professionals who don't have a legal or law degree. So, what is the eligibility and how does the knowledge base compare with these two categories?
Sure. So typically, IP is a very vast field. I mean, IP as such has different facets to it. Patent is there, trademark is there, copyright is there, designs are there. Now even domains are there. Now even data privacy is there, right? So IP has a lot of facets. What I would feel or recommend if somebody is interested in a career, if you are coming from a technical background like engineering or PhD or BSc or MSc, you can actually come and work in the patent, which is more technical field. In India, you can clear patent agent exam. For that, you need a technical degree. For other things like trademark and designs, which is not so much technical, you can build your career with a law degree and going in the law as a normal route to it. Of course, then there are litigators who practice in courts and argue the cases on IP. So that's again, there is always different facets and kind of opportunities within IP. IP is a very broad umbrella of different subjects, and I think that's how if I have to simply classify, either you're on the technical side of it or you're on the law side of it. If you're on the technical side of it, you still need to learn law a little bit, but if you're on the law side, then you have to go so much deeper on the law and however it works. Yes, you need to also learn on a little bit on technology when you're working on patent cases and all those things. So it's like interconnection between, if we are talking about patents as such, it's an interconnection between technology and the law, more in terms of legal conversation.
Understood. So you need both the domain expertise and the legal expertise, and both of these professionals kind of work together in a particular case and so forth. Understood.
Yeah.
So before we go further, what is IP? How would you define an IP? How the law defines IP?
Sure. See, I think there's no definition of IP as a law, right?
Okay.
I think law will define the components of IP, but the way I put it together in the way I also discussed in the book is that IP is something which is creating value and you can't really touch it, right?
Okay.
That's IP. Very simply saying, that's the broadest definition of IP. Even if you're a founder coming from certain backgrounds, certain experiences, that's your IP, right? You can't really touch it, but it's really something which is very personal to you, which is something which is actually you can own. And that's what the IP is in my definition of IP. And then, of course, in the IP, there is a subset of it called IPRs.
Okay.
IPRs means intellectual property rights. Rights means that is something given by the government, or you can actually register those IPs. For example, I can't register my experience as a founder or as a person who has been in the IP industry. But what I can register is the brand name of Arctic Invent and exclude others from using it. So the way we have to think about is that, okay, what is my IP? IP is anything which is giving you value.
Right.
and you can't touch. IPRs are some things which are governed by certain laws, and you can
Okay.
get a right on those by the authorities from
Understood.
different countries or India. So in that rights, there will be patents, trademark, design, copyrights,
Right.
so much. So that's how you kind of define IP in a
Understood.
more logical sense.
Understood. So if there is no legal or if the law doesn't say anything about the IP in general, can there be like two parties who have some legal contract and they define a relative IP between them that is not covered under trademark or copyright or patent, etc.?
Absolutely. So, for example, NDAs,
Mm,
which is the most common business instrument when you are discussing things. That's like, I'm telling you something, which is I'm telling you who is my client.
right.
That's my IP, right? And I'm restricting you from contacting them. It's
Right.
more like a agreement between you and me. A
Right.
lot of IP is governed by these contracts and these conversations and agreements. And as I said, anything which is of value, which is something you can't really touch and feel,
Right.
which is not a physical, then that's IP, right? And that's how you use it in the contract laws and
Right.
everything. So that's how you classify between IP and non-IP.
Understood. So today, large part of our discussion will be focusing on patents. So if we can let's start with like defining what is a patent. And I'm sure since it is a part of the IPR, so law must be having a definition of what is a patent and so forth. So if you can elaborate on that.
Sure. So, see, patent in a very simple sense is given to incentivize innovator for creating a technology
Okay.
or something that they create with their creative and technical minds, mostly technical. Which means, if I say, Bandhan, what is technology? Now, technology is, if you define it from a very scientific terms, technology is basically solving a way of solving a technical problem. A
Okay.
technical problem means we are using phones on a day-to-day
Yeah.
basis, right? Now, phone is enabling us to transmit the data between one device to other device. Now, what is the technical problem here? Technical problem is how you receive the data, packet that data, transmit over the air or using some mechanism, and then decode the data on the other device.
Okay.
Now, if you think about that's a technical problem that how you, and there will be subparts to this technology, which means how you receive the data is a technology, how you process the data is a technology, because there is a
Right.
problem that you have to solve. There is a certain algorithm or certain hardware that you need to use to
Right.
kind of do it, right? And that is where the patent comes in.
Okay.
Right? Is that it will help in protecting those components or technologies or solutions that you have created to solve a problem. It could be, there has been a very famous case on, if you see on the holies, we have these balloons, right? That there are multiple balloons and then you put it
Yeah.
and then
Yeah.
like a lot of balloons are get filled with the water. It's actually a very famous IP case where somebody
Okay.
who created this have fought in the court on, or there was some patent dispute on these things. But again, it was a technical problem that how do you fill
Yeah.
with the laws of physics and everything. It's such a high volume. So it need not to be anything which is only digital. It could
Right.
be anything which is to do with there is a technical problem or there is a problem and you are solving it with a solution. So you get the right on the solution, right? Same for drugs. Like for example, drugs, when we, person kind of finds a new molecule to cure your, heart attack or heart diseases and all those things. That's also like a, technology in a way.
Right.
You have to, of course, validate with the trials and everything. But again, so the way to think about patent is that it is a reward to innovators in exchange of the information that how did you do it, so that after 20 years of your exclusivity, it becomes a public knowledge.
Right.
The patent is created. So if you see as a concept of any IPRs from that conversation, it is an incentive to help innovators to stay innovative by giving them that right that, okay, you can stop others from using it for a certain period of time. Or if you're continue using, like, for example, only in the trademarks, that if you can keep using it for years as long as you are using it and kind of putting the marketing around it and kind of pushing the economy forward. But patent specifically, because we are focusing on it, imagine there will be no generics if we never had these patent expiries, or there will be no worry, we will never know what is inside a certain composition if
Right.
people would not disclose it, what is there, so that we cannot
Right.
replicate. There will be a monopoly of somebody. So there will always be these things that humanity, technology, whatever we create, it is like stored in a patent
Yeah.
database, and the innovators gets a right to exclude others from using it.
Right.
So that's how you kind of wrap around your head on patents, and a lot of conversations around it, a lot of logical questions around it will get answered if we follow the simple principle that it is to reward the innovator and benefit the society, right?
Understood.
So that's how you think about it.
Okay. So if we just see from the patent office perspective, like let's so what do they see in a particular application, like
Sure.
whether this is patentable or not patentable? I'm not talking about if some similar technology already existed. Of course, that is a straightforward thing that you can't patent it. But let's say the usefulness of the technology, is that a part of their evaluation, and what exactly and kind of what sort of mindset do they have, and how the training goes behind their education or whatever to kind of actually analyze and kind of make a judgment of, okay, this, let's go ahead with this and let's reject it.
Sure. So, see, when I given this example that it is a system created to, reward the innovator, but the system also needs a balance to make sure nobody abuses it, right?
Right.
So, what has happened that now when the patent is filed, it is typically judged on certain criteria.
Okay.
The first being the novelty criteria.
Okay.
Novelty means that whatever you are presenting to the office, that, okay, here is my invention, here's my technology, and the technology is defined by the claims or the way you write it and everything. It must be novel. Novel means that whatever you are telling, it's not ever disclosed in any single document or anywhere in the world, right? That you are the true and the sole inventor, which is fair, because if you are saying that, okay, I've invented this, the first test for the examiner is to test whether this person is actually created something which has never been known to the humankind, or
Right.
it is not done by this way, or it is not done, in this technology or in this thing. The second test they do is that, is it very obvious? And obvious means that if you're combining two known things, let's say the item one has been doing a certain activity. Like, for example, let me give a very random example. One, let's say there is a paracetamol,
Right.
which cures your fever, and there is an aspirin which cures your headache.
Yeah.
Now you say that, okay, I'll combine it, and now this new medicine will cure your fever and the headache. So
Right.
it's not a very innovative. It's a very obvious thing.
Right.
You're just combining it with the same effect. But for example, let's say you come up with a specific composition, a specific dosage, that this combination will help you cure your heart disease, for that matter, right? Then there is some certain level of innovation is there. But the second test is all about how obvious it is to combine or just put it the way you are presenting it, right? For a normal person who is a logical person, how in the technology of that, how easy or difficult will it be to just come up with this? Third is that, which we call it industrially applicable or technical in nature. There are certain set of excluded matters, like it should not be harm to the humankind and all those things. The third is the industrial applicability, that, okay, does it really comply with the laws,
Right.
in terms of its area of technology and all those things. So these are the three tests which examiner does. Examiner doesn't care about that whether it will be successful in the future, whether it will happen. What will happen with this technology is not patent office business.
Okay.
Of course, if it is defying the physics and laws of physics, and it's a perpetual machine and all that, then they will kind of object and say, look, you can't really patent something which is not even possible, right? It just it cannot be like a sci-fi thing that you have never practiced it. But the nuance also here is that it's not also mandatory to have a prototype ready.
Okay.
It's also as long as it is not beyond the laws of physics and laws of science,
Right.
and it's a very novel idea, or it is possible to practice it, you can still file a patent on it.
Understood.
But the commercial success is not patent office business. they will only look at the lens from these 3 angles or 4 angles. Is it new? Is it non-obvious? Is it industrially applicable? Is it something technical in nature and aligns with the patent laws? That's it. They don't care about the commercial success of any patent as such.
Right. So can I say this argument that the examiner will give a subjective evaluation? Like, is the result subjective even if it is 0.1%?
See, there will always be subjectivity. See, the way the patent process works, or any IPR for that matter works, is that the first is that you create your application. Of course, you evaluate, work with a professional or yourself. Then you submit your idea to a patent office or trademark office or design office, whatever IP that you are seeking the registration for, you will submit your application. Now, once you submit the application, it will go through an examination process.
Yeah.
Irrespective what kind of IPS, of course, different tests and different logics, but it will go through examination by a human in a way. They will say that, okay, in my view, this is wrong.
Right.
In my view, this is deficient. I need this information and all that. In the case of patent, it's always very subjective because the way I am thinking my idea is non-obvious. You might say, no, it is very obvious. So I have to argue.
Right.
So that's where the whole, prosecution is, kind of comes in. Where
Understood.
once you make an application, they will send an objection. Then you kind of
Right.
go back and forth with them. That's where a professional or, people come in,
Right.
help you in doing. That's like, tax notice
Yeah.
if you get. There's always no subjectivity, which is backed by data. The tax officer will back their findings with the data. Same with patent office. So patent office will say, hey, I found this document which is published in US. I believe that whatever you are telling and this document is telling is the same. That's why I can't give you the patent. Now you go back and say, okay, yes, there's some part of it is there. Let me change my patent claims. Let me restrict my rights, but please give me the patent. So there's always these back and forth conversation between patent office and the applicant, and that's what happens in these things.
Understood. So we have a question from Dr. Moby Luke. He's assistant professor at Chettinad Hospital and Research Institution, Chennai. So he asked, what are the types of patents available all over the world and what are their respective validities?
See, as such, patents or IPRs, they're always jurisdictional. There is no global patent. There are sometimes people get confused with a mechanism called PCT application, which is essentially a way to buy more time to internationalize your patents.
Okay.
But there is first thing is to understand there's no international patent and there's no international one patent valid across different geographies. Europe has some of the groups of countries have come up with a unified patent. Like, for example, in Europe, there is now European patent which covers 17, 18 countries and other countries and more. But there is never these, one patent which covers all. There are different kinds of patent claims. There is no different kind of patents. For example, patent will be patent. But the way you write the patent, for example, you can get a patent on your physical device. You can get a patent on your method, how you work it. You can get a patent on your composition for that matter, right? So the patent itself is not a different type. The technology could be of different types, and based on that, the patent is written accordingly, right?
Understood.
So we must never confuse. There are no multiple types of patent. There are only patents, trademarks, designs, copyrights as those 4 or 5 buckets based on what is the subject of the IP is.
Understood. So this categorization that, this is a design patent, this is a utility patent, this is a so forth. So these are market given categories. These are not like by law. These are, if we talk about mechanical engineering. So there is, let's say someone has designed a particular screw in a novel way. Someone has designed a particular mechanism in a particular novel way. So those are design. So ideally in mechanical also those are counted as design patents. But those are also giving application or utility to the product. So what would that be categorized as within this utility patent or design patent or whatever? And what are these different categories?
So typically, again, if there is a certain way, let's say you created a new kind of screw, right? And which is giving a functional advantage, then it will go in a patent. Of course, as long as it is qualifying those tests of novelty and patentability. Right? If it is just that, I have built this, a screw, which looks very beautiful if you put it in an out open, that it's just design. So the way to think about is that if it is functional, then it goes to patent. If it is more aesthetic, it goes to design. If it is both, you can still file both the patents and design as well at the same time. That's very common.
Understood. So, what are the Indian laws around IP, and we can be more specific about the patents, and how do they compare with US and Europe? Because, as you said, that these are jurisdictional, and also the laws vary, and how strict are the laws, and how enforceable are the laws. So, if you can compare the jurisdictions.
Sure. See, typically, if you look at, from the law perspective, largely the base remains the same across different countries.
Okay.
The nuances change. For example, US may be more software friendly when it comes to patents, but the tests and everything will remain largely the same. The language and everything, laws is laws, but the principles of patent laws remains the same because it's also a global, there
Right.
have been some treaties like TRIPS and Paris Convention and all that, which has largely harmonized all these patent laws.
Okay.
Right? There will be some peculiar differences based on economies. For example, India is called as more pharma-friendly patent regime, right?
Okay.
Especially for pharma-friendly for generics, right?
Okay.
Because the way we have excluded the new use and all those things. Because again, these are very small nuances to it. But if you look from the lens of a general as a business,
Right.
the process of application and argument and the grant will remain the same. It's not different across the countries. It's just that the way they examine may differ from the way India examines the case.
Right.
So, for example, your patent is good to go in Europe, but India may reject it because the laws is very peculiar about that particular subject and all those things.
Okay.
But as such, the duration of 20 years remains the same.
Okay.
Procedurally, it might be a little bit different because they have different rules and laws and everything. But largely, patent does the same job in India as well as in Europe as well as in US. Right. So,
Understood.
I think from a general practice, let's say general innovator point of view, if I have to put it, as long as you know that yes, there are different patents to be filed in different countries, that's all you need to know. The nuances of the law is so, kind of technology specific, area specific, context specific, that I don't think that unless you are planning to be in the industry, it's something that should be worried about.
Understood. Right. So why should someone care about even getting a patent? Like, what is the benefit of getting a patent, and when should someone not go for a patent? And then we'll come to the trade secrets also.
Sure. See, again, it's always something that few things are subjective, few things are good to do, few things are mandatory to do, right?
Okay.
It's like when you're building a house. When you build a house, you typically want to put a fence around it, right? So that nobody comes and steals from your house. Then you put a second tier, a gate with a nice lock on it. Then you also put a window, and then you put a grill of iron around it so that nobody breaks in your house. Same for business, right? If you're building a business, you need to secure it, you need to protect it, right? If you believe that my industry, my area, the way I'm doing it is not something that my area is so easy that nobody is going to break in. I live in an island where nobody, going to steal from me.
Yeah.
That's okay. You can just live without a fence. You can live without a guard. You can live without whatever, right?
Yeah.
So that's one way to think about it. I'm giving an answer in a different sense because then it will give a little bit of underlying thought rather than giving a yes and no answer, because this is how you need to think about it. So
Right.
First is that why you should care is definitely something that it's a general common sense to protect. If you have done something, if it is valuable,
Right.
then you want to protect it, right? For the reason that you want to prove to the world, or when, let's say, you are selling your business, you're selling your land or you're selling your house.
Right.
Typically, you need some paperwork, right? Okay,
Yeah.
This is your house. So patent actually serves those as an instrument. So for innovation business or something which is innovative, patent becomes a currency of its, let's say, the value or stored value, right? For example, a lot of people say Bitcoin is what? Bitcoin is simply the reflection of a value. It has no
Right.
value of itself. It's just a reflection of the way to store the value of a certain technology or certain value. Similar for patents. If you have patents, it basically storing the value of your technology that you have developed as an instrument. That okay, I have created this amazing technology and I filed 5 patents on it. Those 5 patents are the derivative of your creation,
Yeah.
and you can put a value on it. Right?
Hmm.
So that's how you think about the patent. If you believe that no, whatever I have done is not defendable,
Right.
not unique in a nature, it's just hustle, it's just
Yeah.
something which there's nothing unique, and it's absolutely okay to be in that space.
Right.
I'm okay to be not unique, but I know how to do it well.
Right.
In those cases, you might don't want to patent, and kind of that. Yeah, I don't need it. So that
Right.
always is a very contextual in terms of business, what you're building, how you're building it, and also around setting the narrative. If you go in a South Delhi, locality, there is a guard sitting inside the owner can be under debt of hundreds of crores, but from outside it will be like, yeah, he must have a lot of money, right? So sometimes also you have to create those narratives, and patent might help you. I'm
Understood.
not promoting, I'm just saying that sometimes helps,
Right.
because sometimes you have to attract the buyers, attract the people
Right.
around it. But that was one example. But on a real sense, what you need to think about is that what is the use of the patent, you should be clear.
Right. So, but so for example, let's say if I'm someone who has kind of created something and I'm like, it's not from, I personally don't see it very novel or very great, and I ignore the patent. I keep using it in the market. I keep advertising, okay, this is my kind of innovative approach that I have kind of doing, and I feel it normal. And then someone actually recognizes that no, this is actually a real innovation, a real patentable innovation, and then they kind of apply on their own. And so will the patent office accept that patent, or will it discard that, okay, no, someone is already using it?
So if it is a public knowledge, let's say whenever you are doing the business and you have made a public, like you have put it on a paper or something, and patent office discovers it,
Okay.
then that person will not get a patent anyways, because it's known in the public, right? But yes, that's always a real risk. That's why one of the reasons people file patent is that, yes, even if I know that it's something that is not protectable, but I still want to do it because I don't want to block by others at the same time.
Yeah.
And sometimes we undervalue what we have created, right? In a way that it's a good idea. Sometimes what happens that when we create something, we say, it's a very obvious because we are the experts of that area.
Right.
But if you look from a lens of the patent, it might be something that very small thing, but very interesting, very innovative that you might have done.
Absolutely.
So it's always good idea to just check, in any way that, okay, is there any opportunity to do something around it? If there is no, that's fine. If there is, then take a step if it allows.
Right. Understood. So let's come to trade secret. So because that is the other side of the patent, this is something which you design in a way that you want to actually hide, at the same time have a patent around it. So how does this dynamics work, and what exactly is a trade secret?
Sure. See, secret remains secret until it's secret. That's how I say, right? If it is like an open secret, everybody in your company knows, then it's not a secret. That's the first thing about secret. The second thing about secret is that it's like a magic trick, right? If I can figure out how you have done the magic, then it's not a magic. You can't protect that magic.
Yeah.
Right? So the second criteria of secret is that how reverse engineerability works in that space.
Okay.
If I can somehow access your product, or I can get access to your employees, can I reverse engineer that secret? If the answer is yes, the better option is to file a patent.
Okay.
That's the first thing. Now, how these two both work in kind of balance is that some part you keep it secret, some part you do a patent. Of course, patent does mandate, because again, going back to the philosophy of patent, it wants to reward you for your disclosure. But yes, there is always something that you still teach the world, but you still keep something as a secret and never tell the world. But the risk will be that if your secret is patented by somebody else and then they come after you, you are also kind of getting in trouble. So it's always something that is like a Coke formula or Maggi masala. Like if you believe that you can't really reverse engineer or kind of things, then it makes sense to keep it secret. If you believe that no, if somebody looks at the input and the output and kind of do a little bit of iterations, they will find it. It's a good idea to file a patent. I mean, that's my kind of way to simplify this conversation. Otherwise, as an innovator, we always feel that it is my baby. I want to keep it secret. I want to keep it safe. I'll not tell to anybody. And I think a lot of startup dreams also get killed because you get over emotional about an idea or anything. and you don't want to discuss to the world because it's like a car you never drove. And I come across with so many founders, so many innovators who said, no, I will not practice this until my patent get granted or until I file a patent. I said, okay, at least, okay, file a patent, and I don't want to tell the world. So if you
Yeah.
don't tell the world, then there's no business, right? You have to tell the world. So there's always a balance between these things, that if you get too
Right.
over emotional about any of your idea and any business things, it is guaranteed to fail, because you are
Understood.
not even kind of taking it out for a ride and just worried about it getting stolen. So it doesn't work
Right.
that.
So you gave the Coke example. So then how are trade secrets kept hidden? Like small companies cannot afford systems and processes around it so to protect their trade secrets, and large companies kind of they have too many moving parts to kind of prevent a leakage or something, a whistleblower or whatever. So how do you actually make sure that the trade secrets are actually kept hidden by your employees or whatever?
See, typically, I think in the today's world, what is secret, I think what is to be kept as secret is something is always questionable. In fact, I think whenever I meet any marketing expert, they say, tell your industry secret to the world, and then you'll get then you'll get more famous. I think we are now living in an era where people are in a race to tell the secret to the world. Like if you go on Instagram, people will be sharing, tools which have never been told, right? So first thing is to understand that secrets are very difficult to keep, especially if it is something that that is known to too many people, and a lot of people are involved in those conversations. So first is to identify, and that's a half battle done. That if you identify and only test with two simple tests, how many people know about it and how long they're going to be with you. Are
Yeah.
they co-founders? What if they break away? Will they tell to the world and all those things? Second, how reverse engineerable it is. And
Right.
if you answer these two questions, you will get your answer.
Mm.
Otherwise, it's always subjective and subject to interpretation, subject to the risk ability of a founder, subject to my personality. I could be a person who is okay, somebody who's not okay. It all depends on the mindset of the person as well. So I think there's no straight answer, unfortunately, for this. But just to give a framework, this is a framework.
Understood. So, like for example, I have interacted with a lot of deep tech founders, and even those who have filed a patent or even those who have granted a patent are very uncomfortable talking about how exactly their technology works. So, why is this the mindset? What is this the fear that okay, the patent is granted, but still there is some hesitation to talk about the technology?
I think there are two aspects to it. One is certainly is the fact that you have to learn to market these things better. One is the education.
Okay.
That means that even if you're not telling everything, but if you're not explaining what you're doing, then you are guaranteed to fail.
Okay.
So that's my way to think about it. Is that one is that it's a communication problem. That how do you communicate without kind of spilling too much in a way. But if you don't talk about it, then you are guaranteed to not get successful or not get noticed or whatever, right? So that's the first aspect. The second aspect is the fear which stems from what we hear and what we see. Yeah, what we grew up with is that if somebody steals from you, it's very hard to get it back, or who will go in these legal battles. So it's like if you ask any random person, how much money do you own? Will he tell you the right thing? No. If you ask a person, an average person, hey, how much saving do you have?
Yeah.
Will they tell you? Why?
No,
Why they
absolutely
don't?
not.
Why don't tell you? They own it. They
Yeah.
own it legally. They own it.
Right.
But they will not tell you because that's how we're conditioned. Because
Yeah.
the inherent subconscious fear that if I tell to the world, it will be taken away.
Right.
So I think as long as you can recognize that fear and kind of still communicate that, this is what it is, and this is the boundary that I want to keep.
Yeah.
But that's it. I think that's the way to look at it rather than thinking it too much. It's just people. I think founders and innovators love to talk about what they have done, what they have developed. It's just the situation and the scenario. If you're asking them to put everything in public and hey, tell your secret in a podcast, sorry, not gonna happen. But
Right.
let's sit on a beer, ask me anything, I'll tell you everything.
Right.
So I think that's also the thing, right? I think it comes from our motivation to stay safe and motivation to avoid those issues. And that's it. I think that's how we need to look at this rather than overthinking about it.
Right. So that also then brings to this, that what are the actual risks involved in patenting? Like once you have a patent, but still, what all precautions or care you have to take while drafting a patent application or while writing your patent to actually make sure that no one can reverse engineer and kind of do a kind of some minor changes and have their own patent. So what
Sure.
are the things to take care about?
Sure. So first thing is that, look, end of the day, patent is a written document and legal document. And it's like any other document, how well it is written. There has been one advisory from Patent Office, without taking names, where they listed few companies and few online websites which were claiming a lot of different things around patents or trademarks. They were selling like it's like a sure shot will get you and all.
Okay.
So there has been one advisory where against those websites on the Patent Office websites. So again, first is that make sure that whatever document that you are submitting for a patent is a good quality document.
Okay.
Right? The claims are well written. It is compliant with the Patent Office things and all those things. The second thing about quality is that write the claim in a way that it is detectable. Or if you have created some technology, the claim element should be so that you can find your copycats easily, or at least establish that yes, they have copied my technology.
Okay.
By writing the claim in a way that it is more visible in nature, right?
Okay.
So that's something that the second way to write it. Third is to do a little bit of research. What are the similar patents, similar technologies has existed, so that your claims and the patent document is well written, right?
Understood.
See, in the today's age, it is very tempting to just spin it on a ChatGPT, Claude, and all those things. But having said that, it's always a good idea to do it properly rather than not do it. It's like if you have a guard, then at least have it so strength that he can repel somebody. It should not be like somebody just says in a loud voice and he says, okay, sorry, jao bhai. So I think that's how you think about it, that you are putting your effort, you're putting your money to guard something.
Right.
If you're not giving it enough weightage or enough resources, it's better to not have it, because then it will only create bad impressions.
Right.
Which is also happening a lot in the ecosystem, where a lot of patents which are out there are just copy of some research paper, some here and there, and kind of things. Not really innovative, but it just gives a little bit of count kar diya. And there have been, I don't want to stay controversial on this, but it's like there has been some stories on those things. So I think we have to be conscious that if you are writing and if you genuinely believe that you have created something as a new technology, do it properly. Otherwise, don't do it. That's how it is.
Right. And this is very interesting point that you said, that you write the patent in such a way that is also makes it easier for the examiner in future to kind of judge a future patent that might be replicating your.
So Bandhan, I'll correct you here. So if you buy a land and government gives you property papers,
okay,
whose responsibility is to defend or find that somebody is encroaching on my land?
The owner.
The owner. Same for the patent. If you get a patent office does not care if somebody copies you. Okay. It's your responsibility to find who is copying you, take him to the court.
Understood.
So what my suggestion was that when you're writing the claims, let's say you got a patent, but you can't detect who is copying it.
Yeah.
What's the point of it?
Absolutely.
So the way to think about it is that when you're writing the claims, you write in a way that it is detectable in nature. Right. So that when you go out and you find a competitor doing the same thing, you can say, hey, stop. You are doing these 4-5 things. I can see in your process, and then you can take him to the court.
Right.
But I think it's in our conversation, it's a very important point for innovators who are listening in, that it's your land, it's your patent, it's your trademark, it's your responsibility to take care of it.
Understood.
Government cannot take care of lakhs of patents. They have no business.
Right. Absolutely. Right. So then that brings us to what are the kind of methods to recognize that, okay, someone is copying your technology, or like selling is one thing because that is out there in the market, that okay, someone is selling your patented technology. But other than that, if someone has a manufacturing facility, they wanted to use your machine, but actually they cannot afford to buy your machine, but they take out your patent and then they kind of put a makeshift machine at their place. there is no way for a owner to see or find out that okay, these are the people who are kind of using my patent illegally behind the scenes. So what are the methodologies to find
See,
out?
again, if it's a small industry and such a niche industry that only one person is copying, you will anyways get to know about it. See,
Okay.
it's like when any movie is leaked, one or two people get, no problem, right?
Yeah.
But if it's a mass, it's a problem.
Yeah.
Right? Same for, see, if you're running a business, and if you're running any business for that matter, irrespective of patent, you only care about those problems which is troubling you. There will always be hundreds of things which is not going right.
Right. Understood.
Somebody is already stealing from you.
Yeah.
Like for example, if you have 100 people team, there's 2% who is not completing their 8-9 hours.
Yeah. Yeah.
You are
yeah.
okay to let go.
Right.
But if it is like 50% of the people, then of course you'll take action. That's how it works in the business also, right? You never care about those 5-10% of outliers because it's no point fighting them.
Makes sense.
I'm just being, that's how the businesses think in the real world. That if my brand is being copied by a very small set of, let's say, on my technology,
Right.
it is negligible to my business.
Right.
I'll not care about it.
Right.
But if it is affecting me, I'll go ahead and do whatever it takes, right? So
Right.
I think it's always driven by the business decision. It is never driven by the patent. Patent is part of a big picture of business. If there is no business, there is no sense
Yeah.
of having patent.
Yeah, absolutely. Makes sense. So if someone develops a new technology, is the technology by itself patentable? Like in terms of can they get a blanket protection for that technology, or how does that work?
See, end of the day, the way you have to think about it is that in the world today, anything has an alternate and the copy. Like
Okay.
Amazon hai, to Flipkart hai. Flipkart hai, to eBay hai. There's always these things. You will never, of course, in certain areas like pharma, which is very specific, you don't have alternates.
Yeah.
Depends again on the context of this thing, how specific and all those things. But typically, what you are protecting when you file a patent, you are protecting a solution of a problem. Let's say you are solving a data problem or data transmission problem. Now your technology is solving the data transmission by doing 1, 2, 3, 4, 5, 6 steps. Now I come up with a new way of solving that problem, achieving the same amount of results, same efficiencies, or better than that, but with a different method. I will still get a patent and do the same outcome of the business that you are doing. So there is never a, and that's the beauty of the patent thing as a system, because if you think about it philosophically or otherwise, this is also pushing the boundary of human creation.
Right.
If I know there is a block there, if I know that there is a patent for this drug which is curing heart disease, this is already done. Let me create a new molecule. Let me research on new molecule which is far better. And I still need to do business. I still need to do and go do better. So if you think a different societal impact to it, that it is pushing the boundary of innovation, because if you hit a block, you will get around it. Humans are designed that way.
Right. So let me give an example. Like for example, in your case where you have a molecule that kind of is curing some heart disease or whatever.
Yeah.
Now, let's say I'm a bad actor. Like I want to do a mischief. I want to kind of steal a patent. I will reverse engineer it. Let's say you just change a single hydrogen molecule, which eventually gives you a completely new molecule. But then eventually, because that hydrogen molecule wasn't being a kind of interacting with the environment, so will that give me a new patent for the same application for the same technology per se?
That's where the innovative or inventive step comes in, right? That's why these these checks and balances exist. That if there is no, and in fact this is a very big case. If there is a Gleevec case, Novartis versus India, UNF India. There was this same argument that Novartis said, because they want to extend their patents and everything, like they want to file new things. So see, there has been always these checks and balances. That okay, if it is not giving any effect, then why should I give you the patent?
Absolutely.
Right? In the chemical space, there is always experimental data to be given to the patent office to show that yes, this actually works. Right?
Understood.
So again, when the law, see, the way any law in any of the countries or any of the law, if you pick, there's always a balance between these laws. If it is pro patentee, then it is also pro society also.
Right.
So these balances will take care of these things. Look, this law has been there for kind of almost 100 years now, at least if you
Yeah.
look from
Yeah.
a formal law perspective. So that's how kind of you think about it, that that it will take care of itself.
Right. Understood. Yeah. So what's the difference between an invention and a discovery as per the law?
See, invention is that you create with your effort. Discovery is it was out there in the world and you just discovered it. For example, I went to Himalayas and I found Jadi Booty, which is there.
Yeah.
Now I say it's a nature created. Who created this? Nature created. You just discovered it.
But let's say in this particular example, I found a plant. I went to my lab, I extracted the molecule that was giving that particular effect, and I hide about the plant. I just show that, okay, here is the molecule that I have invented. So what would happen in that case?
If you have kind of invented the molecule, then there has to be some experimental data. There has to be something in the long run of things.
Right.
You need to produce that molecule anyway. So you have to show that plant was used. Now there is India. If in case you are taking any naturally occurring,
chemical
element and you are using in your invention, there is something called a NBA, National Biodiversity Act.
Okay.
In fact, now you have to declare that from which origin this stem is coming and it is and how. So you might get a patent around extraction methods and all those things.
Yeah.
But you can never get a blanket, kind of patent on that. Hey, this was there. Like for example, one of the most famous case, I think it's very much talked about, is curcumin case in US. Like somebody tried to haldi, curcumin, which is the base of this.
Yeah.
So it's a very old case. Like I don't want to kind of bore with this case, but this is like a very common case. You just ChatGPT, Claude, or Google it, you will find it. That it's a very common case where people actually fought about it, and it was more like discovery rather than invention. So those things has to be, and that will always be balanced. If there is a good side of a patent law, there will be a bad side of it.
Yeah.
So it's with any law, there will always be like that.
Understood. So what is defined as a know-how? Like, is it the empirical knowledge that you get by hit and trial in the experiments or something?
Yeah. See, know-how is something that even if you know the rules of the game, you play better because you know, or you have practiced it, or you know how to do it better.
Okay.
Right. Same for, reducing to the practice of any technology requires a certain know-hows which are very nuanced, which cannot be captured by the patent itself. And I think that's also one of the major reasons, and I think that's my understanding and my observation. And it's again from a very personal observation point of view, not as an official or professional, that some of the times people say that, okay, I want to commercialize my technology. I want to sell my patents. But people don't buy patents. People want to buy outcomes.
Yeah.
Right? People want to buy your know-how, your expertise along with the patent. So when you're selling your, let's say, IP, Rs or patents, the bigger challenge is that people even have never practiced those things in the field. They have never shown the benefit of those things. And that's why it's hard to sell it. So the first thing about know-how is that these are the softer aspects of things which actually make it successful.
Okay.
Let's say if you have a patent on production of a certain chemical.
Okay.
But how that chemical in practice will be handled from the sourcing to the end.
Right.
The innovator has to tell the person who is buying the technology, or he will know,
But is that patentable? Because that is also a process, right? That you have to keep it at this temperature, you have to do this.
See, again, that will be secret. That will be something which are known to a person, may not be protectable by law. Right?
Okay.
It is something tacit. It's like, there are two kinds of knowledge, right? Tacit and, written knowledge, right? So a lot of tacit knowledge, it's there. It's not like a machine that you can't extract everything out of your brain. Some things are just skill. And that's where the know-how comes in. That know-how is actually, there has been many jokes around know-hows and all those things, right? That so those things which are softer aspect of an invention or a technology is know-how, which actually make it successful. Along with the core technology, it needs to be there.
Okay. So it can be like, for example, for a manufacturing firm, it can be a particular skill or the way the workforce is trained to do a particular task or a particular operation.
Yeah, and also the suppliers, how you will get source the material, how you will sell the market, how
Right.
you put your machine together, what kind of skill do you need, what are the
Hmm.
temperature settings do you need. There are many things, right?
Right.
I mean, the way even to you put up the machine based on the patent, but how to operate that machine is a different skill.
Right. Understood.
So I think while there is a technology to solve a problem,
Yeah.
but it's also there are so many things
Right.
unless you do it.
Yeah.
Right. And that's where the whole commercialization is stuck
Yeah.
around the world, is because while innovator creates technologies, but it's very hard to prove that okay, if you implement this outcome will happen. And that's why businesses are very hesitant to kind of buy these technologies and commercialize these technologies, because they don't want to buy patents, they want to buy outcomes.
Right. True.
You have to tell them that hey, if you buy this technology, your production will become 20x better, you will make this much of money. Patent is part of it. Patent is just storing the value.
Understood. Great. So you mentioned this earlier that US is a good market for software patents. So are softwares patentable, and what the India says about it?
Yeah. See, as such, there are a lot of literature, a lot of confusing literature around it, right? If you read the law, if it says software per se is not patentable, right?
Okay.
There is a section 3K, okay, it's not patentable.
Okay.
Now, but we do a lot of software patents, right? The way to think about it is what we started this conversation with, is the technical problem in the solution. Software, if your software is solving a technical problem, for example, there was this patent which we worked on that you can stream a HD quality video on a 2G bandwidth, right? And it was to do with the way the data was encoded and the decoded at the places. It was just pure software, the way they were encoding, the way they were decoding, and everything, right? Now, the law is not saying that you can't actually patent. So the law is saying that okay, tell me what is the technical problem that you are solving.
Right.
So it's also
Understood.
about articulation and being clear what is it that you're solving.
Okay.
A lot of algorithm patents get patented, right?
Okay.
Algorithms which are solving a real technical problem, right?
Understood.
And it is actually, when you solve this problem, you are making your hardware more efficient. For example, if my LLM machine, which is purely software, is inferencing the data at much higher token rate without changing the hardware, should I not get a patent on it? Because I have created it, right? So again, it is incentivizing my work where I have created a new way of processing the data, right, at a faster speed without increasing my hardware as a stack. I must get a patent, right? Otherwise, why will I do it?
Right.
There will be no technology going forward because I will not invent, right? So again, the way to think about it is that software are patentable as long as your software or algorithm or what you are doing is solving a technical problem. If you say, no, I have created a new CRM, I want to patent it. No, sorry. Of course, but the nuance is I created a algorithm which can predict what my customer will need in the next 6 months based on certain method or certain algorithm and certain data points, which is not possible by human. Probably yes.
Right. So in this case, for example, in CRM, let's say if I go back to the time when first ever CRM was conceptualized, so is that case a CRM? I think wouldn't be a patentable thing because that's an idea. It's not a technical problem you are solving, but at the end it is also a customer pain point that you are solving.
Yeah. So again, the way to think about it is that not all the time it will benefit. Like for a CRM company, their core is that get the customers, get as many users. Their IP is actually their number of users.
Understood.
Right. So it also depends, what is the business nuances and what is the business need to it as well.
Right.
A lot of businesses will never file a patent and still be very successful, makes hundreds and millions more than anybody else, which is absolutely okay. Their moat or their IP is their fund, let's say. For Reliance and Ambani's and for Adani's, their muscle power is their IP, right? I mean, you can't fight it.
Right.
That's how it is. Like if you go, if somebody is more muscular than you, sorry.
Right. So how do you then find out that a software algorithm or a software patent has been breached? Because that is digital. There is no way to find that out.
See, again, that's where the whole detectability and all those comes in. That how easy it is to detect sometimes, right? Sometimes it's also useful in the software industries to actually show that, hey, this is why we are unique. It's a uniquely done algorithm. Patent office has given yes.
Right.
Of course, there will be something which you can still keep it as a secret, which is like a black box and everything. But how well you can kind of reverse engineer and all those things, that's always these questions, right?
Right.
So the way I put it in the software era is that, and especially in the AI conversation, I think a lot of people who are saying that, hey, I've done this AI and all those. So AI stands on two legs largely. One is data, one is algorithm.
Right.
The data is not patentable, protectable in any circumstances. Maximum you can copyright if it's your like personal.
Okay.
That algorithm part, if you have created something uniquely, which is taking the data and doing something like in a new set of ways, there is a possibility of patent there.
Understood. Right. So that answers Ishu Bansal's question, who is the founder of Truck Suvidha. So he asked that whether proprietary data sets or AI models be protected through IP. I think as you answered, data sets cannot be because those are copyright, but AI model could be because that's sort of an algorithmic, if something you are doing or something technical.
Yeah, I mean, what new you have done? Again, patent will always, ground itself with these three tests: novel hai ki nahi, inventive hai ki nahi, and if it is industrially applicable and kind of aligned with our business or not, aligned with the laws of patent or not. Right? So simple tests, right? If you qualify these, great, you will get a patent.
Right.
Will you get successful after getting that patent? Nobody guarantees. Right. That is your business, kind of how you well integrate with your communication, with your business, with your conversations.
Yeah. So can you take us through the process of patenting?
Yeah. So in this, as I said, the first step is the process of the patenting starts with discovery, right?
Okay.
Discovery means whether it is relevant for you, whether it is relevant for your business, whether it is relevant in your technology area. So that's like start from a discovery of why. It's a little bit philosophical, but discovery of why. Once you discover the why, then you try to discover what. Right? What exactly you believe that is going to be patented in a sense, right? Now, once we figured out what we are going to patent, we want to kind of evaluate before even going and taking the pain to go to patent office to evaluate whether it is novel, like doing a mini test. It's like taking a pre-boards, right? That, okay, let me do a pre-board or let me do a search and analysis whether it can be patented. Again, it's an optional. You can straight away sit in a NEET exam, yet do it again. But again, so you take this, we call it as a search, novelty search, so to say. Right? That's the first step. Optional, yet very important if you can do it and all.
Yeah.
So in that you will get an idea, okay, what actually I can file as a patent. Then after that, you prepare your application, like write your patent application. Like any other application, you submit by complying with all the document and paperwork to the patent office and say, sir, here is my application, here is some money. And based on the money, you will get a fast track or a slow track or no examination based on what is the business conversation here. In India or in a lot of countries, you can get a patent within 1 year if you pay a little bit of extra fast track tatkal fee, so to say.
Yeah.
Otherwise, it takes a while. It stays confidential for 18 months. I think the fundamental principle has been in the patent is to stay confidential for 18 months so that nobody knows what you are exactly building, so that you get time and lead time.
Right.
So, but nowadays people say, no, I want to just get it done. I want to finish it off. So you can get within 1 year. So you basically pay a little bit extra fee. The patent office picks up your application, evaluates your patent application on the laws or the criteria that I've told. Okay, is it novel? Is it inventive? Is it industrially applicable? Complies with the law? They will issue a kind of objection, or this is my observation. This is deficient. This is where I feel it is not okay. You receive that communication within a certain period of time. You reply to them, say, hey, here is my response to your objections. They will give you one more opportunity that, hey, I'm not satisfied or I need more answers. Then you can get another round of negotiations with the patent office examiner in that. And once that is done, you get a final decision, yes or no. It can go both sides. Of course, on a statistical level, 60-65% cases gets grant, rest gets no. Depends on how you work and how we work. Of course, the grant rate can be higher or lower based on the firms and how you are doing it and all those things, right? But typically, both the outcomes are possible. You might get a patent, you might not get a patent. Once you get
Right.
the patent, every year you have to pay a small fees, like an insurance fee, to keep it alive, because patent office
Okay.
also needs to run their bills. So you pay a small fees to get it it's like an insurance policy. You have to pay every year a small premium, right?
But since you mentioned that the patent office is not taking care of any conflict or any breach of the thing, so why are they charging a renewal fee every year?
Because it is also maintaining the registry, right? That it is granted, it is alive, you are practicing, you are using it. And a lot of times people who have built a lot of patents, they let go of a lot of IPs because they are no longer using it, right? It becomes public quickly, right? So I think that's also one of the reasons that we want to keep that.
I mean, it's just a text entry in a database. So how much?
I mean, see,
cost
again, they have bills to pay, and it's like a global phenomena, because they have to also run the business, right? They have to also run the office.
Yeah.
And it's like it's like insurance policy. Why do you pay every year insurance?
Right.
They just need to maintain a database whether Bandhan is alive or dead. Right? Simple. But no, they still charge you the same premium, right? Because they have to business to that. But fees are not prohibitive. Honestly, I think government fees around the world, in context of if you look at the big scheme of things, patent fee is never. If your business is successful, patent office will never pinch you.
Right. Absolutely. True.
Right.
Yeah.
So it's like paying your CA or lawyer or anybody else. Right. It's just simple. I think the conversation should be that if it is that okay, if it is that useful for me, then money is not a problem. Right. So I think it's always the context of the business. And
right. So that brings us to the cost involved in all this process, because Dr. Alan George, faculty at St. Thomas College, Pillai, Kerala, he asked that why is it so, it is a bit simpler to file a patent, but the journey from filing a patent to actually getting it granted or getting a decision is quite much more complex and technical and expensive. So what are the costs involved, and why is it so that it might cost a lot more, I think, in terms of the patent consultant fees or whatever that it takes?
Again, Bandhan, I think most of the time what happens, what I have seen in my kind of experience, that if you don't start a journey correctly, then your journey is going to be terrible. If you don't write the patent draft properly, don't do your research, and then expect patent process to be simple, then it's not going to happen.
Makes sense. Yeah.
There is, if it is important for you, right? It's like hiring any professional. I'm not talking any specific to patents or otherwise. It's also important who you work with, right? It's like simple CA, lawyers, anything service. You can say that, building a house is very difficult, right? Because you're trying to do on your own rather than hiring an architect, right? But you hire a right architect, he will do it for you, no problems, right? I think what happens, I'll tell you, and it's coming from the same, from the mindset as India as an economy, people are hesitant to pay for service, right? People don't want to pay for the service. I think that's the right statement. And it is across, probably if I scratch myself, I'll also find myself in that bucket. Because as such, we are never trained to, value the service. As against the West, patent lawyers, charge thousands of dollars an hour, even in the New York, and they'll charge $1,000 an hour, and people are okay to pay that, right? Because I think it's to do with the mindset of finding the right partner and kind of paying them, or don't do it. That's how, again, I say it, that do it properly, otherwise don't do it. Right. And if you can, it's like tax filing. You can do your own tax filing, but you still want to go for a CA, do it, I'll pay some money. Get it done with. Will the notice come or not? How well he has done it? You can always say tax filing is so hard. It's very hard because we did not do it properly when we started the process, right? So it's with the same patent journey will cost, depends on, and see, again, patent journey can cost even less if you write a 1 page or 2 page of claims which offers you nothing as a value. Patent also office say, no, go, your patent are good, but you can't really use anything. It's just a paper. Right? So I think that's how you think about it.
Right.
I don't want to give any price indication because it's very subjective, who you engage with, who you talk to.
Yeah.
But all I can tell you is that when you're thinking about these kind of journeys, even if you're planning to do yourself, understand that this journey is going to take a little bit of time, cost, effort, and all that, because it is meant to be that way. Otherwise, people will abuse it, right? It is meant to balance the disclosure versus exclusivity.
Understood. But is it possible to share a tentative cost? Because as independent inventor Pawan Kumar, he asked that for early stage startups, it is very difficult to have that funding or that finances to actually go through this whole process. So if any tentative average industry standard idea you can give about what stage, how much cost is involved?
Sure. See, first thing is, the good thing about patenting as a journey is that you can always delay costs. For example, if you don't have a lot of money, you can file a provisional. You get 1 year.
Okay.
By the end of 1 year, you file a patent application. Don't request for examination. You get another 18 months to file that examination request. Then the bills will start, right? So first thing, for individual inventors, my advice is that if you have short of money, when you go and start a business, the way you do it, that you put budgets to everything, right? And you put whatever budget that you can spare, you put it there. What happens that IP becomes the last, like a scavenging budget, like kuch bachega to dekhenge, So first is to fix that, right? That, okay, let me put a decent enough budget, or whatever reasonable budget, or I want to put 10,000 rupees, right? I can only spare that much, right? You will always find somebody who will do it in that price. That's the beauty of India as an ecosystem. You will find people who will, of course, the quality and everything, I'm not going there, right? I'll not talk about it. It's not fair. But all I'm saying is that you will always find somebody to do a same amount of job in 10 rupees and 10 lakh rupees.
Right.
So it's very hard for me to give you a number because everybody will have their own benchmarks. It all depends.
True.
You get on Upwork, you get your 3D done within $1,000.
Yeah.
You go to a professional, he will start with 5 lakh rupees.
Right.
But are you comfortable with Upwork or are you comfortable with the person?
Yeah.
It all depends on you and your situation.
Right. Understood.
So I think, Bandhan, it's all I can say. Official fees for an inventor, all in all, if you go for a fast track and everything, is around 15,000-20,000 rupees. The government fees is not a problem.
Okay. Understood.
Right? It's the professional fees.
Right.
If you are going to, it's like somebody going to Ram Jethmalani and kind of things, and then going to a local, kacheri ka lawyer.
Yeah.
It's always
Absolutely.
how much, what persona you are.
Yeah.
If you don't have any money, go on ChatGPT, do it yourself, find a professional to file it for. That's fine.
True.
But end of the day, I think what we try to find is the number. अच्छा ठीक है, कितने में होगा? 10,000 में होगा, 50,000 में होगा, 1 lakh में होगा. I would say do it reverse. Put your budget. How much can you spare?
Right.
And then figure out what best value can you get in that money.
Makes sense.
Right?
True.
Because otherwise, what will happen, if I now today give you a number, that will only block your thinking and say, nahi, itna paisa. So the way to think about it, okay, I have this money. That's how we operate, right, as humans.
Yeah.
I only have 10 rupees in my pocket. I need to fill my tummy.
Yeah.
I'll probably go in roadside. I'm not aspiring to go in Taj because I don't have money.
Yeah.
And then if you ask me, Govind, how much it cost for a meal, I don't know.
True. Yeah.
That's very subjective, right? How much money do I have? It always subjective to it, right? So I don't have money. I'll go to a gurdwara and or mandir and then get my food. That's it.
Yeah.
You don't have money, use AI. That's your gurdwara.
Right. Yeah.
So again, I think, Madan, that's the mindset we should keep. And if an individual inventor is planning a business, 12 months is a reasonable time. You will find whether you will be successful or not successful.
Yeah. Understood. Right. So Lalit Singla, founder and managing partner of SteerX, he asked what are the best practices while filing a patent? I mean, of course, we don't have to go into complete details because that will be depending upon the skill set and the lawyer or the patent consultant. But largely, are there some precautionary measures or some things to see that, okay, these must be there and these are the things that must be followed while drafting a patent application or pursuing it?
Sure. So I think the best way is to look at your claims, what you are writing, do your proper paperwork in terms of who will own it, who is the inventor and all those things, and do a little bit of diligence, what has been already done and all those things in that specific industry and all those things. That will give you a reasonably good patent document. And I think that's the checklist. Otherwise, if you go too much of deep and everything. And also one more thing that I want to kind of tell, that there's sometimes what happens that what you're actually doing in practice and what is in the patent might vary a little bit here and there, but that's part and parcel of the process.
Okay.
Because sometimes what you're doing exactly may not be novel, but you
Yeah.
have to get a patent, and so you have to kind of improvise around it and all those things. So I think
Understood.
that's also something that we have to kind of figure out in that ways, that how you kind of
Understood. And how do you evaluate patent consultants? I mean, what do you see their education background, or do you see their years of experience? How do you evaluate that, okay, this person is right for me to take the process forward?
Sure. See, again, it's always physics, chemistry, and maths. I stolen from somebody, but I'm telling you, this is something I loved it. Physics means, how well, what is their number says, how well they have been doing. Physics, which you can physically or which you can verify that, okay, what is their references, how much is their grant rate, what is kind of, transparency, what kind of mindsets and everything, right? That's like more physical validation. Chemistry means how well do you kind of feel work, and how well you feel connected to that person or that entity or whatever, right? So chemistry. Maths is the maths of numbers. How much do they charge? Is it fit in my business? Does it fit my budgets and everything, right? Simple physics, chemistry, maths, right? If your physics, chemistry, maths match, you found a good partner. If your any of these subject you fail, then it will be fail, right? If you have a great maths but poor chemistry and poor physics, or great maths but good chemistry but poor physics, it will fail, right? You will not pass the subject or pass the class. That's it. So follow PCM method and you'll be fine.
So can you share some examples? Like, let's go with some situations where a particular case is there, and if you can share some examples or case studies that will kind of enlighten the audience. So for example, one in case of any contract manufacturer, for example, if you are doing a contract manufacturing and you have a particular trade secret, or you not even a trade secret, let's say you have a particular thing and you have to send the CAD files to someone, or you have to share the specifications of the tooling. So how do you ensure that, okay, the contract manufacturer is not going to steal the know-how and kind of sell it on their own going forward?
Well, I think there are two aspects to it. One is human aspect to it, right? Human aspect is that you have given me something valuable. Will I steal it or not? It's a function of how good a person I am, right? It's very hard to kind of say that whether Bandhan is a good person, Govind is a good person. You will only get through once you do it. That's the first aspect. In any of those things, there's this human aspect to it. The second aspect is the legal aspect to it, right? The legal aspect is that how well you have communicated to the person who you are giving this contract. Do you have enough paperwork, enough checks and balances? Have you reviewed their own kind of processes, that okay, how many people will be exposed to this information at their end? Maybe the founder is a good person, but the operator who is in gloves with your competitor might be the person who has leaked it, right? So how well you have diligence your contract manufacturer is also something that you have to do, right? If your maths, because you're only looking at maths and not looked at the physics and the chemistry,
right,
it's not law's fault, right? So I'm just telling you practical examples. I'm not talking in a lawyer's way. I'm talking from a more business point of view. Right. I mean, I'm an engineer. I'm not a lawyer, so I'll not talk a lot of law. I mean, I'm telling you the fact of the life, fact of the businesses in that way. Right? Yeah. Of course, you do your paperwork. You do your contract manufacturing agreements. You do IP clauses. You do have IP joint clauses and everything. You do your IP clauses, kind of correctly. But at the same time, you have to make sure that you are looking at these human factors and those things, because that's real, right? Sometimes you tell your contract manufacturers not everything, maybe part of it. I met a founder, a deep tech founder. What they have done smartly, that they had few components in the machine that they wanted. They picked up 7 vendors to do all those 7 other components, so that one person does not know what the other person is doing.
Understood.
That's how they protected their IP.
Right.
So it's also that if you know what is valuable, you will always find a way to protect it.
Right. And that brings us to the earlier case also, which we discussed. Like, for example, Coke is a very good example where they were able to prevent that no employee of Coke has ever kind of leaked in the public the kind of the composition that is there. So similarly, how do you prevent an ex-employee or an employee who kind of steals the know-how and then they leak it in the public?
See, again, these are general observations and may not be the most apt answer. I think there are a lot of case studies around it. But my sense and my personal sense on it is that first, Coke has been diligent in not telling a lot of people around these things.
Okay.
1%, there's no single point of failure as such, right? Even if you have parts of information, it's very hard to put it together. And then a lot of times you do have these, leaving agreements with a lot of your employees, like, that, okay, you cannot disclose these things, and there are certain rules and, so you can also have those agreements in place, and also, exclusivity of the information has to be there.
Yeah.
Right? And sometimes you have to live with that risk, right? That, okay, if that's it, then that's it. I mean, look at today. Even if Coke formula is out in the public, how do you think how many people will compete against Coke, right?
Absolutely. Right.
The kind of muscle and the kind of supply chain control they have, I don't think even if you know the formula, you can compete with Coke.
Right.
It is what it is, right? And I think the way to think about is that how diligent you are in terms of protecting your IP or your secrets around it. So,
right.
Yeah.
Right. So we touched upon this a bit earlier when you were discussing regarding the chemical aspect, the chemical industry. But like if we talk about academia and experimental research labs, so how much importance the lab notebook plays? Because then because there are also cases where a PI can kind of steal a student's particular work and kind of publish it on their own or patent it on their own without having the student as the author. So how students can avoid it and what role the lab notebook plays?
See, again, I think having this conversation more candidly and kind of with the supervisor, and also keeping these lab books actually can, let's say if somebody has misused and taken your technology, at least you can use these lab books for proving that that you have done this invention. So for that perspective, definitely you must have those records. And there are in India, at least there are a lot of laws around proving that if somebody proves that this patent has been filed fraudulently and all those things, you will get those patents and everything. So there are things around it. And see, it's very simple. That let's say you have 1 lakh rupees, right? You want to establish the trail of ownership, right? Same with IP. If you have a trail of ownership, so the lab book is nothing but a trail of ownership. So if it is valuable, create a trail of ownership so that you can have that, those, if in case required, you can use those. Like if somebody takes your 1 lakh rupees, then you can say, hey, look, I have noted the serial number of the notes. Here is my record. This is why it is mine, right? And I think that's what is the importance of this record keeping and everything. And I think for a lot of audience, a couple of movies I would recommend. One is Flash of Genius. It's a very, very good movie. Very interesting, very entertaining. About inventor who fought with a lot of automobiles for intermittent wiper. And the latest one being Zootopia 2. Zootopia 2, it was about, patent was actually helping the person establish the ownership or the original creation. And I loved it because I think patents also serve, irrespective of whatever, it also serves at a little bit of a tool to establish that you are the one who created. Irrespective it failed or it does not happen. But it also satisfies sometimes our egos as well as innovators, right? That, okay, yes, we are the ones who have created it. So that's also a good use of IP or patent in a way.
Right. So lastly, like for example, if I am someone who has kind of spent years on R&D and with my own brilliance, I have developed a technology that is novel or something according to me. But then when I go for a patent or I do market study, I see that, okay, someone has already patented it before. So then what options do I have? Because I didn't know about that technology before. I didn't reference it while building. It is something that I spent my money and my efforts and my resources on building something from scratch. So what does the law allow you to use it in that way if you have something, or what is the legal aspect to it?
See, it's like, mujhe pata nahi tha, but I did it. That's first, it's not a government's problem, it's your problem. If you have put a lot of effort and you could have done a landscape, you could have studied the market better. So it's not government's fault.
Right.
That's one. Second, what you can still do is that if you see that the other person who have done this before does not have a patent in your territory or in your country, you are free to use it because it's a public knowledge.
Yeah.
Right? So government rule is very simple. By first come, first serve. Doesn't matter how much effort. It's like NEET के center पे delay हो गया, sorry, I can't let you enter. ठीक है?
Right.
So that's what it is, right? That you have to understand that rules are rules.
Right.
Rules cannot be changed for a situation and for emotions. What you can practically do is that look at, the practical, if that patent is not existing and you are free to use it, go ahead and use it. And, it's absolutely fine.
But where does that leave the grassroots innovators or people in rural places where they don't have money or resources to kind of buy the software, the AI tools to kind of do the market study and find out? So where does the grassroots innovators are left at?
See, again, there are agencies like NRDC is there, all those things which are actually, kind of doing almost like a free, NRDC is one of those things. And there are other, institutions are there. A lot of universities have this incubation and IP cells and all those things. Look, I understand but that's how the world operates, not only in IP, otherwise also, right? I mean, unfortunately, no matter whatever, how unfair it may sound, but that's the world we live in. Sometimes you have to just accept it as a reality, and then nothing can be done about it. I'm just being a little bit more blunt about this situation, but this is what it is.
Patenting has become a capitalistic game in this society rather than what it originally was meant for, like to kind of progress society, advance civilization.
Yeah, but I think it is true with everything. I mean, even criminal laws and everything. I mean, come on, which law? Again, if you go in that direction, then everything will become like shit, right?
Yeah,
I mean, but there's always these balances. There has been so many stories. In fact, there is a website, if you want to, that we have created, cases.arcticinvent.com.
Okay.
Where we have collected all the IP cases in a very simple language, like, US, India, Europe cases, where you go and, kind of go and find out. You will see there has been stories where, people have taken bigger brands and bigger companies in the, courts and won. It's just a matter whether you want to fight this battle or not. What is important for you?
Yeah.
I think capitalism or otherwise, if you go in that direction, everything will be in that favor. I mean, then, whole conversation will fall in a different dimension. But I'm just saying that, look, this is what the reality is. Business requires money. Business requires capital. That's a fact of life. The era that we are entering, you need more and more capital to do a business. That's also the fact. Like, it's public news.
Yeah.
So, of course, everything is getting, complicated, expensive. But that's what the world is. I wish we have a reset button, but we don't.
Great. Yeah, so thank you so much, Govind. I learned a lot new things talking to you, and thank you for joining in.
Thank you.